న్యాయమూర్తులు, దేశ అత్యున్నత న్యాయస్థానమైనటువంటి సుప్రీంకోర్టు ఆఫ్ ఇండియా న్యాయమూర్తులు గౌరవనీయులు మాన్యులు శ్రీ పిఎస్ నరసింహ గారు జ్యోతి ప్రకాశాన్ని గావించారు. అలాగే మరి తెలంగాణ రాష్ట్ర ఉన్నత న్యాయస్థాన ప్రధాన న్యాయమూర్తులు శ్రీ అలోక్ ఆర్య గారు మరి జ్యోతి ప్రజ్వలన చేశారు. అలాగే బార్ కౌన్సిల్ సభ్యులు శ్రీ రాజేందర్ రెడ్డి గారు మరి జ్యోతి ప్రకాశనాన్ని గావిస్తున్నారు. అలాగే ఈనాటి కార్యక్రమానికి చేసినటువంటి విశిష్ట అతిథి శ్రీ ఆర్ సంతాన కృష్ణ గారు మరి జ్యోతిని వెలిగించి ఈ కార్యక్రమాన్ని
Public Prosecutor, High Court of Telangana and former Bar Council of AP. Chairman Sri R. Santana Krishna Garu, Supreme Court Senior Advocate and Nivarana Mediators of Supreme Court, Senior Advocates, Judicial Officers, Members Bar Council of Telangana, Members of Bar Association City Civil Court and other Bar Associations, Judicial staff, staff of the Bar Association, the people of electronic and print media. I welcome you all for today's function. As we all know that we are here on the event of a lecture of Mediation Act 2023, role of bench bar mediators and litigant public in the memory of late M.L. Ramakrishna Rao Garu, Honorable Sri Justice B.S. Narasimha Garu, the Chief Guest of today's function, was associated with the office of eminent lawyer late Sri M.L. Ramakrishna Garu. His Lordship Sri Justice B.S. Narasimha Garu was brought up in Hyderabad. He graduated from Nizam College, Hyderabad. After receiving a Bachelor's of Law in 1988, he practiced at Andhra Pradesh, within Andhra Pradesh High Court. Lordship's father, Kodanda Ramaya Garu, was also judge and legal writer. Honorable Sri Justice B.S. Narasimha Garu then moved to Delhi to practice at Supreme Court. He was designated as senior advocate and was appointed as Additional Solicitor General of India in 2014. In August 2021, he was appointed as Judge Supreme Court of India. Honorable Sri Justice Alok Arade on 29 December 2009 was appointed Additional Judge of the Madhya Pradesh High Court and served the different states. In July, Lordship Alok Arade assumed charges as Chief Justice of our Telangana High Court. Honorable Chief Judge City Civil Court Srimati Renuka Yaragaru is humble judge and maintains a cordial relation between the bench and bar and a good administration. She has been very cooperative in all the activities of the Bar Association and keen in the upholding the dignity of judiciary. Sri M. Rajendra Reddy Garu, the Public Prosecutor, High Court of Telangana, was a former member, Bar Council of India and Chairman, and is a man behind the today's event. He is the chief coordinator for the today's function and the inspiration for several advocates. It would not I say that today's event would not happen without him. I thank you for all the efforts, sir. Today is a great event, as we know that nowadays it is a mediation that is playing a big role in the justice delivery system, and we are here to know about our role as an advocate in the mediation. I feel honored to address this august gathering. I welcome one and all. Thank you.
Judge Supreme Court of India, Honorable Justice Alok Arya Garu, Chief Justice of Telangana High Court, Honorable Chief Judge Civil Court, Hyderabad, my good friend Mr. Santana Krishna, President and Secretary of the Bar Association, senior members of the Bar, A.K. Jayaprakash Garu, P. Shankar, Bar Council member, Mr. V. Patabi, senior advocate, Mr. Sunil Ganu, senior advocate, Mr. Dushyant Reddy, senior advocate and founder, president of the Advocate Vijay Society, Shri Mohan Rao Garu, senior members of this bar, Lakshman Sharma Garu, Additional Soldier Judge of India, Dr. Praveen Kumar Garu, Assistant Soldier of India, Ramakrishna Reddy, Charapati, Binoy Miles, and Vice Chancellor Nansar, Sir Krishna Devata Garu, Honorable Judicial Officer, Honorable Justice Lakshminarayana, sorry, Lakshminarayana Garu, Honorable Justice Sujana Garu, Mr. Pramod Kumar Kedia, District Judge Ranga District, Registers, Assistant Registers, all my brother and sister life, good morning to all. I take privilege and great honor to conduct this program in the name of my mandate, great senior Sri M.L. Ramakrishna Rao. I joined the office of the Sri M.L. Ramakrishna Rao in the year 1980. Sorry, Madhu, I forgot you, Mr. Chandra Madhu also there, Sundar Reddy. During my education, law degree, I used to meet Justice Kunda Madhav Reddy Garu some occasions. After completion of my law degree, I went to Justice Madhav Reddy Garu. Sir, I want to practice civil side, that to civil side, trial court. Then he suggested Mr. M.L. Ramakrishna Rao, one of the eminent civil lawyer in Hyderabad. You go and jail there, and immediately called him to requested my senior, Mr. Ramakrishna Rao, I am sending one young boy from rural background. You want to jail your office? Practice. Then I joined the office because the great their blessings of the both the Kunda Madhav Reddy Garu and the M.L. Ramakrishna Garu. I am here standing before all of you. So I take an initiative to unveil the portrait of my senior. I invited Justice Venkata Ram Reddy, Supreme Court Judge, during 10 years or 15 years back. Then now this is the second occasion to do something in memory of my senior. So I thank you all of you coming and attending this function. Especially I thank you Justice Narasimha Garu and Justice Alakarate Garu attending this program, accepting my invitation. Now I request Mr. Sunil Khanu, Senior Advocate, to say something about my senior.
Justice Mr. Alakarate Garu, Honorable Chief Judge Srimati Renuka Yara Garu, my dear friends, Santanam and Rajendra Reddy, Honorable High Court judges who are also attending the function, other judicial officers, and my brethren friends, brothers and sisters, very good morning to you. As far as I am concerned, I think Almighty has given me a privilege to interact with late Sri M.L. Ramakrishna Rao sir in various capacities. If you ask me what I felt, rather what I looked up, how I looked up at him since beginning, when I came in practice in 1980-81. He was a person, the most senior member at the bar, and in those days, in 70s and 80s, there were two offices, with grace of God, which were flourishing. If I may say so, because somebody's problem becomes a lawyer's practice. M.L. Ramakrishna Rao sir's office and my senior late M.L. Ganu sir's office. Almost in each matter we used to be in adversaries. But at the same time I had seen an excellent camaraderie between my senior, who was much junior to late Sri M.L. Ramakrishna Rao Garu, while they interacted in the court or otherwise. On one occasion, as it used to happen in our office, our senior used to push each one of us. If I may say so, my then senior colleagues, Mr. Vilas Abdulpurkar, who later on was elevated as a High Court judge, then my other senior colleagues, Mr. Arun, Mr. Madan Mohan Nath, and then my turn came one day to do a final hearing on my own. And I think that was just about 3 or 4 years in practice. I had prepared myself well. I interacted with senior. Senior had said, yes, I will come and argue. And when the moment came, he said, what is there? You are prepared, you go ahead and argue. And now here comes the greatness of late Sri M.L. Ramakrishna Garu. A senior told me, who is that? I said, no sir, you please come. M.L. Saab is coming personally to argue this matter. So I don't think I should go and argue the client and what to do, I don't know. M.L. Ganu sir, my senior said, what is there? You can't get a better senior to appear against you than M.L. Saab. He is a thorough gentleman. He will never take advantage because the junior member of the bar is appearing against him. He will never heckle you when you are making your submissions. He will let you submit, but that doesn't mean that you should be half prepared. In today's world, I really look at it and try to remember, if I can say so, about other seniors members in the bar who are practicing, as to whether each one of us can say so about each other. I went ahead and argued. M.L. Saab heard me patiently. When we came out of the court hall, he patted me on the back and he said, you are well prepared. These couple of things you need to look at once again, and all the best to you. That was the day in my life. And thereafter, God's grace and your cooperation and the Almighty, I never looked back. But then, if you ask me as to what really matters in the formation of a good lawyer, is such encouragement from seniors, the stalwarts at the bar. I remember M.L. Saab as a thorough gentleman, a man with mild, loving personality, but at the same time, an intense adversary when he is in his robes appearing against you. And that is what we are supposed to be. My memories about him, see, immaculately dressed, always in white, well-polished shoes, very pleasant demeanor, and even at that age, he will never go by the lift. He used to walk up the steps all the way, and he used to tell us, be active and be well prepared and be pleasant when you are making your submissions. The demeanor should not be trying to belittle the adversary or the honorable judge. See, if I may say so, whatever contributes in your formation as a lawyer, as all of us know, you naturally try to follow your own senior. But at the same time, as we were taught, whenever you get free time, be in the court halls and observe how other seniors perform and argue. And I would say, I learned a lot from late Sri M.L. Ramakrishna Garu. I really feel fortunate that I got a chance to observe him. In his last days, in fact, another memory of mine is, in his last days, I think about 4 or 5 months before he passed away, he called me once. I was wondering how M.L. Saab has called. I went. And he told me, Sunil, these are 2 matters which I want you to take care. I was pleasantly surprised, but at the same time I said, sir, I don't know the client. He said, don't worry, I have been observing you. You are doing good work. I wish you all the best. Take care of these things. I really feel there can't be a more kind of encouragement in this life than this from a great stalwart like him. I remember him for all these qualities and in him, and I look up to his memories. Thank you all.
Thank you, Sunil Bhai. Now I request Mr. V. Patadi, Designated Senior Advocate, High Court of Telangana.
Honorable Chief Judge of the Civil Courts, Mrs. Rekha Kayara, and Santanam, my very good friend, and Mr. Rajendra Reddy, who was my senior in college, 3 years in college, the Honorable President, the Honorable General Secretary of the Civil Court Advocates Association, Honorable Judges here, the Honorable High Court Judge, and all my learned brothers and sisters, the Honorable Judges from the Civil Courts and Criminal Courts also, I suppose. My entry into the profession was in December 1980. I did my law in 77-80. So straight away I joined the office of this Padmanabh Reddy, the famous miraculous criminal lawyer of those days. I never had any occasion to practice on the civil side. But after about 4 or 5 years of my practice, I had occasion to appear in some civil matters and that too some company matters. The first matter I appeared was, my adversary was Ananta Babu Garu. He was a giant of the personality, an amazing advocate. So I was having a tough time facing him, and then the court was, I think, first senior civil judge then, by name one Mr. Ramakrishna. That Mr. Ramakrishna, I have never seen such a judge. He always used to say, judgments are at my fingertips, come on, he used to incite people to argue. So when I was sitting and trying to take my presentation, first time Mr. M. Ramakrishna Rao Garu came and sat next to me. So that is when he said, Prakash, don't worry about who the other side is. Please always remember the concept of David and Goliath. The other side may be a high personality, towering personality, but there is always a Goliath in you. So he told that he once appeared for Nizam's Railways and the adversary there was Nani Palkiwala. So Nani Palkiwala was a giant those days. And he told Patabi, I did my job and I won the case, Nani Palkiwala lost. So this is the first encouragement I got from him. In another case where it was a company matter, it was before one Mr. Durga Prasad, if I remember correctly. So other side was S. Venkatreddy Garu. He was also a towering personality. He was Advocate General. And there again, Mr. M. Ramakrishna Rao Garu came. He told Patabi, studying is not enough. You need to learn the art of court practice, your behavior, your demeanor, etc. So I didn't know till then that Mr. M. Ramakrishna Rao was father of Mr. Harsha. Harsha also was my senior in college. I think it is Rajendra Reddy, Harsha, they were all classmates, senior. So once when I went to see Harsha in his house, I saw Mr. Ramakrishna Rao sitting in his office. He simply called me to his room and then he started talking to me as if he's my childhood friend. So he started narrating some experiences and about the mischievous things or smiling things or humor he had in court. So one day he was telling that, I think again it was on the same Mr. Ramakrishna's court, he was cross-examining a witness and that man was giving erratic answers. Ultimately, judge also cautioned him saying that you cannot do that, you are a witness in the court, you have to answer the counsel. Then that man screamed saying, I am an IS officer, I am not going to answer the way I want. Upon that, Mr. Ramakrishna Rao, he simply said, okay, if you are an IS, add one more yes to it. So upon that, the judge laughed, all the advocates laughed, and that is when that IS officer got under control. So this is the sort of subtle humor Mr. Ramakrishna Rao used to present in the court. One other incident I had occasion to witness was, this was just before the principal chief judge, Mr. Lakshmareddy, right. So what happened was, Mr. Ramakrishna Rao has filed a suit and it was returned with multiple objections. Mr. Ramakrishna Rao requested the section to post it to the court for orders. When the matter came up, the judge asked, what are the objections, Mr. Ramakrishna Rao? We are just watching it. So he said, sir, one more objection was not raised. What is it? They did not say why I filed a suit. The judge laughed and said, okay, immediately give numbering to it, and he also gave the interim orders. So this is the sort of subtle humor Mr. Ramakrishna Rao used to have. As Mr. Sunil Gano was telling, Mr. Ramakrishna Rao had a fantastic personality, a tall, towering gentleman, so soft. He was a giant in personality, as a legal luminary, and yet so kind at heart. So he was so nice and he used to encourage us. Though I did not have the privilege of how Mr. Rajendra Reddy, Mr. Justice Narasimha, Mr. Sunil, how they all had the privilege of being in the office of Mr. M.L. Ramakrishna Rao. But still, he has inculcated a lot of value system into me, which I am sure I am trying my best to keep it up and share it with the rest of the advocate colleagues here, so that we all should see that these are the towering personalities who have kept the flag of judiciary flying high. There are such eminent personalities across the country who safeguard judiciary and who see that the judiciary continues to get its respect and adoration. So he has been an icon for all of us, and I am very thankful to the organizers of this meeting to let me say these few words. Thanks to one and all. Thank you.
Krishnan to say his experience about the mediation, the Supreme Court and other areas where he attended.
Other dignitaries on the dais, my friends from the bar. First of all, let me thank the organizers, especially Mr. Rajendra Reddy, for giving me this opportunity. I just thought, let me briefly trace some sequence of events which led to this Mediation Act 2023. While the British colonial system took over, till then we had something called the Panchayat Raj system, which was trying to resolve the disputes across India and beyond. So far, we have been practicing this adversarial system. Adjudication is the method to which the disputes are resolved. In the process, there occurred docket explosion. With the introduction of reforms in the 1991, economic activities increased. Along with economic activities, commercial activities, the Commercial Act and the commercial transactions led to explosion of docket, and that led to a serious thinking what should be done. In the year 1996, the then Chief Justice of India, Justice Amity, invited an institute based in the United States, the Institute of Study of Development of Legal Systems, to have some kind of interaction with the Indian counterparts. That was broadly linked to the study of the institutional backlogs in the justice delivery system. In this process, they gave certain recommendations as to how to cope with this kind of development. During the same time, there was the 129th Law Commission report which recommended introduction of mediation. Alongside, Justice Malibat Committee also recommended that mediation should be a binding obligation on the courts to explore the possibility of settlement. In view of these developments, there came an enactment, an amendment to the Civil Procedure Code, Section 89 came into being, and it took its effect from 1/7/2002, where it was obligation on the part of every civil judge to see, after the framing of the issues, to explore the possibility of settlement. If they find there is a possibility, then the ADR mechanism would be invoked. When this act came to be challenged, in the year 2003, Supreme Court in Salem Bar Association case, apart from upholding the enactment which brought an amendment to the CPC,
directed framing of a constitution of a committee which will give us the model rules. That was upheld in the year 2005 in the second Salem Bar Association case. During the same year, the then Chief Justice of India, Justice Lahoti, on the administrative side passed an order through which a mediation and conciliation project committee was formed, and Justice Santosh Hegde was its the first president. From then on, the mediation took the forefront, where first we saw the Madras High Court forming a mediation, court-annexed mediation committee. Similarly, Delhi took the cue, we had Samadhan getting into action, doing the same thing, and slowly and steadily it went across the length and breadth of this country, where importance for mediation started assuming a role as an alternative dispute resolution mechanism. And in this process, there came the year 2010 when the Supreme Court in the AFCON infrastructure case removed certain anomalies which the sections 89 of CPC brought in, and thereafter the mediation as such, the mediation enactment which brought in the amendments of the CPC came to stay. Slowly and steadily thereafter, through various enactments since 2013 and 2019, we saw the Companies Act followed by its rules, the IBC Code, the RERA Act, Commercial Courts Act, and the amendment that was brought in the Consumer Protection Act, brought in the element of mediation as a possible ADR mechanism to resolve the disputes wherever it was possible. While India was grappling with all these developments, we were not isolated. The major economies in the world were equally grappling with these thoughts, and that led to the United Nations in the year 2018 passing a unanimous resolution bringing in the fact that mediation, especially the cross-border settlement through mediation, should be recognized and given effect to. This led to the Singapore Convention in the year 2019, August 2019, when Singapore Convention was brought in, where India also became a signatory. This was akin to the New York Convention of 1958, where arbitration was given its importance as an alternative form of dispute resolution. Once India became signatory, it was not only obligatory for India to give a formal recognition to this scope, to this process called mediation. Since then, discussions took place, experts were called for, consultations were done, and ultimately that led to the enactment of the Mediation Act 2023. Today, Justice Narasimha is part of this MCPC of Supreme Court. As I told you, both the initiations from the MCPC with regard to encouraging mediation across the country by creating establishments across the country on the one hand. On the other hand, we had enactments which brought in the element of mediation to be introduced. Now, since we have Justice Narasimha as part of the MCPC, in the recent discussion with him, and I am sure that the entire mediation landscape would change in the days and years to come. Thanks for the opportunity.
A few words about the functioning of the Mediation Center at Hyderabad. This is what.
2nd March 2030 by Honorable Justice Kabir Garu, Supreme Court Judge, along with Surinder Singh Nija. Justice Chalmeshwar was also present here, and at that time our Chief Justice was P.C. Ghosh, and our Chief Minister Kiran Kumar Reddy, and our portfolio judge Mr. Justice Ishwaraya, along with Justice Raghuram was also there. They have, and also Justice M.V. Ramna also came to the inauguration function. Initially, the second floor of the Legal Services Authority building was allotted to the Mediation Center, and Justice Ishwaraya Garu was the portfolio judge. He requested Mr. Rajendra Reddy Garu and also requested all his seniors who were his classmates in Nizam College and Law College, and requested all the seniors should also become the members of the Mediation Center so that amicable solutions can be found out. So on his request, Mr. Rajendra Reddy, Pramod Kumar Kedia, G. Arun, Mr. B. Shankar, Dilip Kumar Jaiswal, R. Prakash, Devendra Rao, myself, and all other senior advocates also have undergone compulsory 50 hours training as contemplated by the Supreme Court. After also we attended 3 or 4 refresher courses in even Judicial Academy, and from that time we are regularly devoting almost every week 1 day or 2 days completely to the Mediation Center. And still, my request is section 89 of CPC is not followed. Only 90% of the cases are family disputes are only coming to the Mediation Center. Civil disputes are not coming there, but only in partition matters, because parties, when it's referred also, they are not turned up in the Mediation Center, except the family disputes where both were there. We compulsorily conduct the mediation, 3 sittings we are conducting, 3 sittings compulsory, devoting more than 1.5 hours, 2 hours time, because the presiding officer may not have time in the court to dispose of the mediation cases also. 90% of the family, almost 100% of the family court cases are coming to the Mediation Center. The seniors are also who got roaring practice also devoting the time to the mediation, and with the help of all the colleagues, now almost 50 trained mediators are in the Hyderabad Mediation Center. With the help of Chief Judge, we are conducting regular mediation in the court, and I request all the judicial officers also to refer the other matters also to the Mediation Center so that there can be some amicable settlement. So I thank you very much for giving me the opportunity to speak. Thank you.
On the guest here, with the permission of the Lordship, we request the President to come and offer a bouquet to the Chief Guest.
Request Sri Palle Nageshwar Rao Garu, the President, High Court Bar Association, to come on to the dais and present a bouquet to the Honorable Justice Sri P.S. Narasimha Garu. Next, Deekonda Ravinder Garu, President Bar Association, RR District. I request him to come on to the dais if he is available.
And out of 14 hours of this case were free. I was so scared how to inform the seniors and what to do. I just, during that time, remember the president of the association, sir, I'm scared, it will happen like this, what to do. He patted me and said, don't worry, this is it, you said, don't worry, we'll sort it out. And then he was invited to bar room. Leonard James was invited to the bar room at lunchtime and explained the system. We were having 40 courts there. It is humanly impossible during the advocate to be present during the Padwa. These are the difficulties of the city courts. If it is Loxin courts, definitely 1, 2, 3 courts, it is no problem to. But in this kind of, and we used to have criminal court at nearby this place, small palace court at Usmania Medical College opposite, then control at Malinjai Market, City Government. So many courts Then immediately the landlord realized that and he swore to restore all the matters during the course of the day. What I meant to say is, he was so tactful. In fact, there could have been some kind of resentment from the God. But in avoiding that resentment, he controlled everything was sorted out in seconds. So he is so tactful and I learned so much from him that as of today we are continuing in profession, his role is there. As Sunil Sir said, we used to sit in his courtroom where he was arguing, conducting the cross-examination, chief examination. So we feel honored to be present on his memorial function day. Thank you.
Honorable P.S. esteemed Secretary of the Project, Mr. B. Lakshmi Sharma, Minister for Citizen of India, Renuka Yara, Chief Justice of Hyderabad, Mr. R.S. Krishnan, Advocate Supreme Court of India, and Convener, Nivaran Mediators of the Supreme Court of India, Mr. Vinod Kumar, and Mr. P. Ashwira Reddy, President and General Secretary of the Bar Association of Citizen Court of Hyderabad, Mr. M. Rajendra Reddy, Public Prosecutor, High Court for the State of Telangana and Coordinator of the Trust, Mr. Sunil Ganu, Mr. S. Palchar, Mr. H.S.G. Rao, Mr. Bhattavi, Senior Advocate, undergraduate members of the bar, Vice Chancellor Nalsa, ladies and gentlemen, a very good morning to all of you. It's indeed our privilege that we have amongst us Justice P.S. Narasimha, who will shortly deliver a lecture in the memory of late Shri M.L. Ramakrishna Rao, Advocate, who was known to this bar. I am told that he was a source of knowledge on the intricate issues of law and procedure for the judges. I am also told that he had the uncanny ability to convince the most stubborn judges and had mastered the art of cross-examination. We celebrate a transformative milestone in the landscape of dispute resolution and commemorate the advent of Mediation Act 2020-23. Mediation as a means of dispute resolution was always ingrained in the Indian jurisprudence. The Parliament for the first time attempted to streamline the mediation and legitimize its increasing relevance in the life of a dispute by codifying the mediation as process of alternate dispute resolution. The Act is intended to promote institutional mediations, the resolution of disputes, and to enforce mediated settlement agreements. The Act also provides for a body of registration of mediators, encourages community mediation, makes online mediation acceptable and cost-effective process, and establishes a regulator to regulate the mediators and mediation institutions, that is Mediation Council of India, and introduces disclosure safeguards for mediators. Mr. Justice P.S. Narasimha, an eminent judge of Supreme Court of India, needs no introduction to this audience. His Lordship was designated as Senior Advocate in the year 2008 by the Supreme Court of India and has appeared in many public law cases including constitutional, administrative and environmental matters. Honorable Chief Justice Narasimha has expertise in law relating to telecom, electricity and other regulatory jurisdictions. As Additional Solicitor General of India, His Lordship assisted Supreme Court of India in several landmark cases including the celebrated NGSE judgment before the Constitutional Bench of the Supreme Court. I am conscious that I stand between you and Honorable Justice P.S. Narasimha, as everyone is, including me, is eager to hear him. This lecture will definitely enlighten us on the Mediation Act as well as the role of bar and bench as well as the mediators. Thank you very much.
Thank you very much, brother. Now I request Honorable Justice P.S. Narasimha, Chief Justice of the function, to deliver the memorial letter.
Our Chief Justice, Justice Alok Aradhe, Justice Lakshmi Narayan Garu, Justice Sujana, Judge of the City Civil Court, Renuka Yara, and her companion judges, my dear friend Santana Krishnan, the President of the Bar, Mr. Vinod Kumar, and then the Secretary, Raghavendra Reddy, of course, the organizer, the friend Rajendra Reddy, very important thing, Mr. Harsha, my friend Pramod Keria, and in a way my group, Sri Jayprakash Saudal. Rajendra Reddy gave me a list of your friends who are here present. In words of our great Tyagaraja, who was to address at one time a big gathering like this. So what he did was, he merely sang a song by saying, Yandaro Mahanubhavu, Andariki Bandam. Lots of very heartening to see so many my friends, my colleagues, and I also acknowledge the additional Solicitor General and also the Vice Chancellor Krishna Deva. There are, I should say, three reasons why I am very happy to be here. The first is, of course, to be present on an occasion to deliver the keynote address on mediation in honor of Sardar Ramkrishna Rao. I had a special attachment for him, of course. Second, very, very important reason is to be addressing the members of the City Civil Court and in the premises of the City Civil Court. This is again a matter of very important significance for me, and which I will shortly be relating to you about it. Thirdly is I am back to Hyderabad, and this is the place of my actual birth and also the place of my professional birth. So these three reasons makes me happy, and I had the good fortune of meeting M.N. Ramkrishna Rao when immediately after my enrollment, my father had called him and requested him to guide me for an exposure of the original jurisdiction of the civil side. I was told that there is no other option if you want to know the civil jurisdiction except to attend the office of Mr. M.N. Ramkrishna Rao. Of course, at that time, Harsha was my first senior, and he guided me and introduced me to the basics of civil law. Ramkrishna Rao Garu is a pre-independence person. He was also pre-constitution advocate. These two are very important factors because as time passes by, another 10 years from now, such people could virtually be endangered species. These are the people who have seen us through what we call, when all of us, our parents and our forefathers were subjects of the British or the Nizam, so to say, and they have seen the transition from being a subject of a ruler to that of an honorable citizen of the Republic of India. That is the great part of such people who would have seen us through, and they, I think, give us the opportunity for some more time to serve them and remember their sacrifices. That is the reason why I was very particular that I should come for this occasion. He studied in Nizam College, the same college that I had gone to, and he did his law from Pune, and famously conducted his duty as the principal government leader. During which time, I believe he had the occasion of briefing a large number of senior counsels to whom he learned, and they were the doyens of the bar, Mr. N.S. Raghavan Narasimha Iyengar, the great Narsaraju. He mentored a number of juniors. He heard them speak to us and relate their experiences as they worked with them. Mr. Granu also spoke to us just now. Mr. Guru Rajara was also one of his juniors, and unfortunately last time I couldn't be here, and Mr. Guru Rajara came all the way from Bangalore, and I missed that opportunity of being with him. I also had the chance of seeing him as a senior counsel appearing in the High Court as I got enrolled and entered the bar. I also saw him, I also briefed him, and also appeared against him in the Supreme Court when he had shifted his practice there. There are very many other other counsels who he had mentored, like M.L. Ramakrishna Rao, former governor, Mr. Satyanarayan Reddy, Mr. R.A. Krishna, Narayan Reddy, and of course, our Rajendra Reddy, apart from Vilas and Mr. John. His ability, I believe, was really in dealing with cross-examination, and he could get through to any tough witness and could convince the judge with authority and conviction. And some instances were also recounted where he had demonstrated his continuous wit and humor. I believe when he was conducting the trial of Sri Salarjan Baudou, when the judge commented that that related to a matter of succession under the will, and the judge commented that where there is a will, there is a way. And Ramakrishna said, "No, my lord, where there is a will, there are a number of heirs." Those who have practiced on the civil side, either in the civil courts or in the High Court, or perhaps somebody like me who have practiced in the Supreme Court for matters coming from Hyderabad, know how many heirs the Nizam estate had created over a period. It's also related that he had appeared against Parasaran, the former Attorney General, in the Raj Kishan Prasad's famous case, and that was argued before T.L.N. Reddy, who had taken on to kill the judge of the High Court. And his performance was so good that Parasaran walked up to him and congratulated him for his performance. And here, of course, also appeared against Balkiwala, as was related to us. As I was telling you that Hyderabad had actually been a place where one would say that where north met the south. We had the actual cosmopolitan composition in this place. We had people we had Kannadigas practicing here, we had people, Maharashtrians practicing here. Pramod Kedia is an example, Ramuji is an example. Large number of us, we became part of their lives and they became part of our lives. So we worked together, and it was a beautiful culture that we all practiced together and shared each other's ideas and thoughts. That's what enriched Hyderabad, in my opinion. I used to come here in my younger days to buy manja for flying kites. And it was a beautiful place at one time. Life also changes and changes drastically from time to time. As our introduction was being given by somebody speaking in Telugu, that Telugu Haru means Gongura ante Chitikaleskori Vaskaru. And whether it's Gongura or Punnaganti Pura, as many of us know, this is a transition in life and a transition for good. And I want to highlight that plurality. The Honorable Chief Justice was taken over and has been taking keen interest. The plurality has actually been the part of Hyderabadi culture, and we were persons who had liberality in our thought and thinking. Last week I was in Jaisalmer. Normally, not being a judge in the High Court and having gone to the Supreme Court, I have not much experience about being a High Court judge. So I take special interest and go extra mile to understand the district and the High Court judicial systems wherever I go. So the bar in Jaisalmer got to know that I was there, and they had invited me, and I hazarded. The culture most of the time is that they start working at 7 o'clock in the morning and complete the proceedings before lunchtime because of the heat. And each place has its own culture, and it is in this context that district courts play a very, very important and vital role. Unlike high courts where we deal with laws and interpretation, district courts, apart from doing that, are integrally connected with the people. They have to know the culture of the people. They have to know the attitudes of the people. They have to know the environment, the structure, and everything. As I told them that I can also speak in Hindi, I said I will hazard my Hindi in my Hyderabadi Hindi. And they were all very excited and immediately related some of the jokes of Mahmood to me. So by the end of it, I said, when they asked me to come back in a typical Hyderabadi way, I said, "Aaya to aaku, nahi to nahi." Chief Justice perhaps will get to know what it means. This is typically again a Hyderabadi way of saying, "I'll try and come." And this is the part of the beautiful culture that develops in a district court. There is a reason why I am mentioning to you about the district courts and the significance of a district court and their connectivity with the people. It is in a recent decision I had highlighted that in All India Judicial Officers Judgment. I had highlighted and thought it important to mention that district judiciary is a part of the basic structure of the Constitution. Because of the role that it plays, apart from upholding the legal rights and safeguards the personal liberties, it formulates itself as an important public good. In the sense that through the process of district courts adjudication, there is definitely resolution of disputes of individuals, where the system that is offered in the form of a civil court provides the method of access to justice. When laws are being considered while adjudicating disputes, the decision making is actually a demonstration of the public values. people will get to know what a promise is, and people will get to know that we must abide by promises. And such values are considered, declared, and relief is granted. These are not merely interpretation of the provisions. These are the temples where the values are actually declared. The significance of the civil court lies in provisioning the infrastructure for adjudication and for a better life amongst us. This therefore takes us to the very important question as to what have we done through the process of district courts all these years. Whatever we have done, the tools of such mechanism were the tools of adversarial litigation. In simple terms, from the commencement of the Constitution, of course the same method was prior to that also, but let us recount it from the commencement of the Constitution. The tools of adjudication and determination were to determine what the truth of a fact is. We thought justice could be done by finding out what is the truth of a fact. The entire process of adjudication is based on this simple solitary principle. If it is a specific performance suit, has he agreed to sell the property or not? If it is a cruelty in a case of a matrimonial dispute, whether the husband or for that matter even the wife has shown cruelty in her actions. Whatever the dispute may be, the inquiry which our learned judges will carry is to find out whether this fact is true or not. Then how do we find that out? Because truth is not so easily decipherable. So we evolved a system of a lawyer taking one extreme and stating what all evidence is available to say that the fact exists. And there is another lawyer who would produce the evidence to say how the fact does not exist. It is between these two contests that the learned judge will pick up what he thinks is closest to the truth. This, in the simple words, is the definition of adversarial litigation. If you enter the mind of a judge, the truth is again not a fact. The truth is what the judge conceives to be a reasonable fact. So we are back to square one, where decision making and justice administration depends upon the perception of a judge in the context of competing claims of fact. We continued this model for years, and today if we turn back and see, has it really served us very well? I don't need to tell you, because you all know about it. Has it really served us well? The pregnancy, the registrar was telling me that the pregnancy before this court is about 57,000 matters. And Chief Judge corrected me that during her tenure it was reduced to a good extent. Now it is 52,000. So 52,000 cases to make an estimate as to how long it's going to take. So this is where we are today. Perhaps I'll speak to you like a heretic, having become a judge directly from the bar. But these are stark realities which look at us. and we can't escape from them, we need to answer them. Mr. Santana Krishnan has said, related mediation in the context of the docket explosion. That's also a factor, but added to that, now look at an alternative to adversarial system, the problems that it posed to us from the commencement of the Constitution, apart from the docket explosion. The ultimate decision on the basis of which we will have to conclude that justice is done because decision is made. And the decision is carried to the higher court. And after that the Supreme Court, because it's not infallible, but that's the last court, we would confine ourselves to the decision of the higher court, Supreme Court also. But it's the only system that's made available to us. What then is the alternative system? It is in this context that I look at mediation. Apart from docket explosion, mediation will live or die depending on the conviction that we have on mediation. If it is merely yet another alternative like that of arbitration, which became more or less an elitistic methodology of adjudication, we will still be nowhere. Arbitration has not really taken off. If it were so, then we would not be facing so much of tendencies. First caution that we must administer is to ensure that mediation doesn't take the same route as arbitration. It must subserve the poor. It must subserve the common man. It must subserve one and all in an equal way. What happens in a mediation is one question which is still in my mind, for which I don't have a full answer, which I will share with you shortly. Mediation, in the context of how good it is as a revenue model for a lawyer, is a fact which we will have to still work on. But there is no doubt in my mind that as a method of determination of disputes, the resolution of disputes, it is a far better system than the adversarial litigation. Simple factors. While justice system in adversarial litigation is centered on a judge, and a judge's perception directly leads to a determination and justice, quote unquote. Many a times, a judge's determination is substantially influenced by lawyers. Substantially. Many a times it's more. In regulatory jurisdiction like electricity regulation or telecom regulations, we have a terminology called the regulatory takeover, where the institutions which the companies which the regulator wants to control themselves take control of the regulator. Like electricity companies take over the Electricity Regulatory Commission and guide them towards profit. So this is something which one has to be very careful. Similarly, of course, our judges are very well used to however impressive an argument is by a lawyer. They just have learned the technique of detachment and finally apply their mind and come to a conclusion. Whoever the senior counsel may be. That's a very, very good technique which they have gathered over a period of time by consistent and constant application and through, of course, mentoring to senior judges. As against this, mediation is self-driven. The decision making is of the person who is in trouble. It is his decision and only his decision. He coordinates with the other person with whom there is a difficulty, and through the process of a mediator, they arrive at their own decision. So it's highly empowering. It's highly empowering, and very importantly, it makes them responsible for their own decision, as against the common trend of judges taking the blame, and sometimes lawyers also taking the blame. There are very many other advantages. You all know about it. Mr. Santanam also has related to us. The technical jargon that we have developed over a period. You don't need to tell him what a res judicata is. For him, if he is happy that he can settle a problem at one level, he will go ahead with it. There is a very important aspect in mediation which relates to confidentiality. You don't need to call the husband and wife into the court, or even brothers into the court. We have seen so many partition suits. In my initial days, when I was looking into some partition matters, simple questions come up to our mind. We stop questioning such things. If two brothers want to partition their property, should it take 25 years? Ask ourselves simple questions. Should it take 25 years for brothers to this partition? What have we done to our system? And who has benefited? Nobody has. I'm sure lawyers were not read about this fact of the matters of telling. It's a systemic problem. These can be answered. Enforcement is again an issue. In adversarial litigation, EP is life too. It's a rebirth of a case. Once a EP order is done, is a story and a life in itself. Order 21, so to say. And then, lastly, what really impresses me is it brings in a very important constitutional principle of fraternity. After all, the life is short, and mediation helps you come together. It allows you to reconcile and tells you that you and him or her are more important than the material wealth in between. The fraternity, which is one of the most important and the most subtlest of the constitutional values, will be reaffirmed through the process of mediation. That's the reason why mediation becomes important. And it is, of course, a win-win situation. Once you settle, you always get more. It is in this context that I go back to the thing which is troubling me a little bit for some time. Where is the revenue model for a lawyer? Are we to treat mediation as a system where we do it for charity, we do it out of volition and because of good feeling, and also for moved by the fact that somebody who has come to you cannot afford it, which is the most common thing. I was in US, for them legal aid is a very huge project. As is always in America, they convert their business approach to virtues. But so far as we are concerned as Indians, our feelings towards helping a client are really genuine. They are not farcical. If we do legal aid day in and day out, I know all of us would have done it in any number of cases. Those who have become judges are those who. The question needs to be answered. The question needs to be answered because then, nevertheless, there must be a revenue model. And the new act has a schedule which talks about it. I was talking to some youngsters who are involved in mediation process here. says that initially when a client comes, we have a discussion with him, we will fix the fees. And normally he was saying that nobody comes in the way of the mediation coming through. Sometimes there is a misinformation. Sometimes there is an apprehension that this might lead to a situation where lawyers might be briefless. But it's only a misconception. Over a period of time, you will realize that it is not true. And that mediation will have a revenue model in it. And the numbers that they are, and the system of mediation will move from what is now the normal state, which is mediation in the context of matrimonial disputes. We will move on to mediation in matters which are commercial in nature, where high stakes are involved. Then the ability of a lawyer to mediate and bring about a resolution is of immense value to both the parties. One of my last dealings about mediation was when I was asked by Justice Bobde to do the BCCI mediation. Large number of cricket associations were involved, and over and above that, Supreme Court had appointed what's called a COA, Committee of Administrators. So a lot of bad blood between the associations and with the COA. So as always the case of a lawyer, when I was asked to be a mediator, I had gone through the entirety of the brief, read the 6 judgments on record, read the society's bylaws and all that. And when they came to me and I started telling them what I thought was the best way to resolve it, one after another silently heard me. And as the last person was about to leave, he said, "You are also just like a judge." I was quite shocked. So I said, "What's wrong?" He said, "Aapko sunne ka time nahi hai." So that left me with a thought that there is something wrong with my approach. As I thought about it, we are all trained to understand the problem and resolve a solution in our mind and suggest to the client or to the judge what needs to be done. We need to unlearn that. I believe lawyers are very good learners, though slow. We will over a period of time unlearn our techniques as lawyers and learn the new techniques. What are the new techniques? The first one is to listen. Provide space for the persons who are in trouble and just listen to them. My experience after that thought, when I called them back and did nothing but just kept quiet when they talked to me, the eyes melted one after another. They told them what the problems are, and by the end of it they said, "We only wanted somebody to just listen to us what the problem is." And as they related their problems, the solutions emerged one after another, because they themselves will tell you the person who is affected is the best person who will tell you what the solution is. Each of them will tell us where the key to the solution is. So these are the techniques that we need to imbibe, and there is, I'm sure, sufficient amount of resolution through the model of mediation which satisfies the parties, the clients, and also the mediators. There is yet another aspect of it, and that relates to the mediators. The mediators, again, are persons who need to train themselves, attend the regular seminars and classes that are held. It is picking up, but Honorable Chief Justice was also telling me that 2 or 3 seminars were conducted here. I had also come about 3 months back. A training for mediators. It's very important to have mediation training for senior advocates. All of those who are sitting on the first bench, so to say, if I can say so, your experience is phenomenal. Your contribution will never ever be forgotten by this and the 2 succeeding generations if you take one step ahead and contribute towards the resolution through the mediation process. What about criminal law? That's the biggest docket that we have. There also, I think there's a great amount. Of course, we have it, and Mr. Pratap will tell us. We have the process incorporated in the Criminal Procedure Code, where we could resolve even criminal cases through 320, if I'm not wrong, Mr. Pratap, through the process. 420, no, 320. Yes. That process must be enhanced, and very many disputes, even criminal disputes, can be resolved so very easily. It's not a difficult process at all. I think I should end here. The reason why I was relating to civil court is that my brother is not here. Immediately after I enrolled myself, he had asked me to appear in this court. And it was just 4-5 days. So he said, enter appearance and take a date. So I had no idea what entering appearance is and what is taking a date. I appeared before a judge here who later became a chief judge. And as I walked up to him, when the matter was called, he said, he asked me, has the wakalat been filed? I had no idea. So I told him what the truth was. I said, I have no idea. The judge was furious. He said, when did you get enrolled? This very court. He said, about a month back. I said, is that an answer to give to a judge that I have no idea? So, these are the aspects which remain with you for a long time. And the client promptly reporting it back to my brother. And a kind man as he is, he, as usual in his Hyderabad Hindi, he said, how? And he said, all right, we will handle it. And I continued in his office. And I'm thankful to him for his kindness. And it's a very happy time for me to be amongst senior counsels, advocates, judges, and over and above anything, friends of mine. And I always look forward to coming to Hyderabad, particularly to the civil court. And this is an opportunity which we must not miss. I think we are a very, very great nation. We are great people. At every instance in life where India is tested for its abilities, we always come out with flying colors. My belief in us grows in leaps and bounds. When I read Aurobindo, he had long back predicted that the time is going to come for India. we are at the verge of it. We are arriving at that situation. We need to be confident about ourselves that we are the good people. And there is a great challenge for us, and that lies in how we need to contribute for the rest of the world. The contribution of each of you, each one of us, is going to make a difference to us. We need to climb this one little hurdle of moving from the existing system to that of a system where dispute resolution becomes as easy as possible. And with that, we firmly the constitutional, the three ideals of liberty, equality and fraternity will easily be achieved. And with this, I take leave. I thank the trust, I thank the Chief Justice, and I thank the Chief Judge, my friends, and the presidents of the bar, learned judges, senior counsels, the Vice Chancellor, everybody. Thank you very much for giving me this opportunity.
I had the privilege of appearing for your father, Justice Kodanram. I saw him as an advocate, then when he got elevated to the bar also, lecture. I had the privilege, and he was such a kind person, not only me, any youngster. He used to mentor them and guide them. He used to tell, please read the provision of law and come back to me. So that is one thing. Second thing is that you are not in that speaking about mediation, and that was criminal cases. One occasion, he held a sitting at his house at Mahubala. I think you stayed there at Mahubala, right? So, a criminal case, he governed the parties, husband and wife. I said, why can't you settle it? Why do you want to go on the court and why do you want to ruin your life? Two sittings he had, and the parties compromised and started living back. So, all I can say is, of course, you are Raghu's brother. Raghu was 1 year junior to me, but you are a lucky son of an amazing person. This is Kodanram.
So many of councils here supported me when I was a young lawyer. Thank you. Media is here. Thank you very, very much.
ఈ కాలాన్ని నిర్దేశించి మనకు అందజేసేటటువంటి క్యాలెండర్ రూపంలో మన ముందుకు వస్తుంది.
Honorable Chief Justice, Telangana High Court, hand over the judgments of the Honorable Justice Kodanram Garu to Justice P.S. Narasimha.
This is an invaluable treasure that I have ever got.
మరి ఈనాటి ముఖ్య అతిథి శ్రీ పిఎస్ నరసింహ గారు గౌరవ న్యాయమూర్తులకి మరి బార్ అసోసియేషన్ సివిల్ కోర్ట్ హైదరాబాద్ వారు మరి చిరు సత్కారాన్ని అందజేస్తున్నారు. ఈ కార్యక్రమంలోని వేదిక మీద ఉన్నటువంటి అతిథులందరూ కూడా పాల్గొన్నారు. గౌరవ న్యాయమూర్తులు శ్రీ అలోక్ బారాణి గారికి మరి కేరియా గారి చేతుల మీదుగా చిరు సత్కారం. నౌ ఫెలిసిటేషన్ ఇస్ గోయింగ్ ఆన్ టు ది ఆనరబుల్ జస్టిస్ శ్రీ అలోక్ బారాణి బై బార్ అసోసియేషన్ సిటీ సివిల్ కోర్ట్ అండ్ ఫ్రమ్ కేరియా. శ్రీమతి రేణుకా యారా గారికి మరి బార్ అసోసియేషన్ సిటీ సివిల్ కోర్ట్ హైదరాబాద్ వారు చిరు సత్కారాన్ని
City Civil Court Hyderabad and late Sri M.L. Ramakrishna Rao Advocate Trust. Let me first of all start by giving glory to the Almighty God for making today's occasion resounding success. At the outset, I thank our Chief Guest, Honorable Sri Justice P.S. Narasimha Garu, Judge Supreme Court of India, who despite his hectic schedule accepted our invitation to deliver the memorial lecture on the topic of Mediation Act 2023, role of the bench, bar, mediators and litigant public. We are very much inspired by the lecture of the Honorable Justice. We are grateful and convey our sincere thanks to the guest of honor, Honorable Sri Justice Alok Aradhya Garu, Chief Justice, High Court for the State of Telangana for inspiring speech. I thank to Srimati Renuka Yara Garu, Honorable Chief Judge, City Civil Court, Hyderabad, for her cooperation and taking time to grace the occasion. I would like to express my gratitude to Sri R. Santan Krishna, Advocate, Supreme Court of India and convener of Nivaran Mediators of the Supreme Court of India for having come here and grace the occasion. I thank all honorable judges of the High Court for the State of Telangana, registrars and honorable judges of the City Civil Court and other honorable courts in and around Hyderabad for participating in this program. I also thank all the senior advocates, my brother and sister advocates, presidents, secretaries and other executive committee members from the various bar association and judicial staff of the City Civil Court, Hyderabad. An event of this magnitude cannot be organized single-handedly. It requires team perfectionists to accomplish the task. I thankful our young and dynamic president Vinod Kumar Marudi, Bar Association, City Civil Court, Hyderabad, and executive committee members, and Sri M. Rajendra Reddy Garu, Public Prosecutor, Honorable High Court for the State of Telangana, and coordinators late Sri M.L. Ramakrishna Rao Advocate Trust, Sri Pramod Kumar Kedia Garu, Advocate Chairman of the Kedia Cyber Cave, and Sri P. Janardhan Garu, former President and trained mediator for their contribution and support in all possible manner to organizing this event in success. I also thank distinguished invitees present here accepting our invitation and special thanks to the Police Department for extending support in organizing this function peacefully. Last but not least, I extend my thanks to the members of the electronic media for interest in covering the event and all the good art who worked behind the screen. Thank you, one and all.
भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मागे गाए तब जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 जय